All right, I've got to record it. Good, thank you for that, Sharon. Record.
This meeting is being recorded.
Right, we're on record now, everyone. So we have to, and then I'm over there on the YouTube as well. So I'll just put you up there. So put the view on the gallery view. Right, so everybody here, we've got Jodie, we've got Kate Floss, that's me, got Sharon, and there's Sharon, and then we've got Brent. And so we've got half of our Oreo team. And Diane's not able to be with us today. And Maxine might come later. If anybody's on the YouTube, you can't see if you're on the YouTube, I have actually put it in the link. If you go to my YouTube, you'll see in the link there. I think I can even put it on here. I can. Can I put it on the live chat? I don't know why that doesn't come up. Hold on just for a minute. Remember to guard privacy and abide. We don't want to learn. Oh, you're only allowed 200 words. Oh. I think I can, all right. So I can take all the numbers out. Right, there's Maxine.
Hi, Maxine.
Oh.
Hello.
I'm trying to put this meeting up. So I'll just remove, you're allowed only 200 words. So I think I can take that out. Can take out.
Just put peep show.
Peep show.
Yeah, Kate's peep show.
Kate's peep show. Yeah. That's funny. Kate's peep show. That's just.
Well, we're peeping into an envelope.
Well, no, we're peeping in. We're peeping in, yeah, we're peeps, the peep show. Kate's peep show.
Don't say Kate's peep show because you could get flagged for that.
We've already said it. It's already on the. It's on the live video. Eh?
Yeah, it's okay to say it on video, but you can't put it into words and use it as a title.
ID passcode. I'm trying to put this up for the people. All right. Right. So anybody that's on the YouTube, you might be able to click on that link that I've posted. I'm not sure if you can. And you might be able to join in the YouTube if you want. But right. So the verdict today. So we've got a few people on the YouTube. Got 4 people. And then we've got you people on the Zooming, and what we're going to be opening the verdict today. So that I did already mention before, but I'll just mention it again for the newcomers. Can everybody hear me nicely? Is that we had put in the original case, but that original case has become irrelevant because they struck us out, and then they sent us to. I went to the appeal court. And as soon as I hit the appeal court, they whacked me with the $1,000 filing fee. And then as well as the $1,000 filing fee, they also whacked me with a $7,000 security fee. Now, what is the security fee? The security fee means that even if you win the case, the people that have you've called to the court get paid anyway. And this happened in the Fitzgerald case in 1976. He took Prime Minister Muldoon to the court, and the case is irrelevant, but he won his case, but he had to pay the $3,000 fee anyway, even though he won his case. So I brought up that case, and I said to the court that according to the 1688 Bill of Rights, that it is the subject's right to petition the king, and any commitments for doing so are illegal. That means any forcing of us to pay to go to the court to petition the king is illegal. So we've sent that on the first $1,000 one. Now, don't worry, because if we lose that, the next one we will fight is the $7,000 security fee. And I've got some extra things to put in now because we keep learning as we're going. So we've learned some extra ones as there. So let's just introduce the people here that we've got that we're going to the court. Of course, well, we can look up the top there because we've got here Queen Elizabeth and we've got Prince Charles, and they're the holders of the 1688 Bill of Rights, and they're the people that own the Queen's Army. Of course, we've got the Queen again that dates all the way back to the time of Jesus. For Jesus, he was taken to the court of the unhewn stone and he was prosecuted with no fair trial, slapped around, beaten around, and taken to the cross, and they never wanted that to happen again. So that's why they made the courts of the hewn stone. That's what we go to, is the court of the hewn stone, where the laws are fixed. They don't just make them up as they go along. And this one is the Chief Tamati Wakanene. Now, Tamati Wakanene is pivotal to the people of New Zealand because Tamati Wakanene worked together with Queen Victoria and the Germanic tribes that were brought out from Germany to come to New Zealand to put us all under the written common law for our protections. So Tamati Wakanene is very, very important man. The other one we've got over here is Andrew Little. And Andrew Little, what's he the minister of? He's the minister of yes, he was the minister of health. We've got Chris Farfoy, who is the minister of justice, and we had said that he's incompetent because this man was a newspaper reporter, dropped out of school, a high school dropout newspaper reporter, and he was the Minister of Justice. So we have said that he's unqualified to his position. We've got Ashley Bloomfield, who was a doctor, and Ashley Bloomfield has, and then we've got Jacinda Ardern. Now, I just want to remind you before we go ahead and open that none of these people are guilty of anything at all. In the 1688 Bill of Rights, it says that if we have a question about the law, that we are permitted as common law people to go to the court and to petition the court and ask them about that question of law under the 1908 Declaratory Judgment Act. And so the people that you call to court are not guilty. They're not even called defendants. They're called respondents. So I just really want to make that clear that none of these people are guilty for anything. And it does say in the Cabinet Manual that if they were not in that position in Parliament, then they never would have been called to the court in the first place. So they're only called to the court because you're questioning a law that was made in Parliament. And the laws that we are questioning are laws that were created when these four were not even, some of them weren't even born yet. So we're fighting for the 1688 Bill of Rights. So the first step is to fight the $1,000, and I'm going to go and I'm going to open it up and I'm going to read it to you. And it's going to be, all right, I'll put my YouTube over here, and I'm going to, here, okay. So I'm going to go and open it. I don't know what the verdict's going to be, but if you're on the YouTube, I'm going to read it to you. Okay, if you have any comments, you can say hi. We've got 6 people in. Opening up the verdict. Oh my gosh. So I'm going to open it up on the YouTube. I'll be posting it later so that with all of the pictures and everything, so that you can all see. Right, can you all see my screen now?
Not yet. Yep.
Yeah, and is it quite big enough?
Not for me. I need you to read it.
Yeah, I'm going to be reading it for sure. Right. So I'm going to be reading it to you. So it says here, this is from JC McGrath, and it says here, please see the attached decision on the application. You're going to be
There's an
all so
attachment.
angry with me. The verdict's not in.
What's the attachment?
Yeah, this is so the verdict of the 1,000 is not in. We had on the 7,000 security costs, we had asked them for a suspension of the $7,000 security fee until we had the verdict of the $1,000 filing fee. And then I'll just show you. So what we originally got,
It was good practice.
it was good practice, but we have not got it. So we got a note from right. So we had a note in regards to that from Rebecca, who had said the respondent understands Ms. Sixtus has applied to the Court of Appeal to defer the date by which security costs must be paid, and for an extension of time to make any further application under 35.6 in respect of security costs. So this is not the $1,000 filing fee. All right.
Really?
So this is different. Okay, so we still have to go and see what he says though. So he's just given us on the decision on the application for deferment in respect of security costs. So let's see what he says here. So he says, Dear Ms. Sixtus and Counsel, this appeal was accepted for filing on the 21st of June. Security for costs was set at $7,000 under R35 of the Court of Appeal Rules 2005 rules. On July 19th, Ms. Sixtus applied for a deferment of the date by which security for costs must be paid or be the subject of any application for suspension or reduction. Ms. Sixtus is awaiting a judge's decision on review of my decision, declining to waive the filing fee for the notice of appeal. She seeks, that's me, a deferment of any issues relating to security for costs until after that fee waiver review has been determined, as there is a possibility that the judge will be able to answer a point of law that she is not clear about. The respondents have no objection to this application. As there is no objection, I consider the deferment should be allowed. That's a small win, okay. Pursuant to RR 3560 and 3510 of the court rules, I defer the date by which the security for costs must be paid and extend the date by which any further application may be made to 10 working days after a decision is delivered on review of my decision declining to waive the notice of appeal filing fee in this appeal. So that you see here, Catherine Ann Sixtus Verse, Jacinda Ardern, Chris Farfoy, Andrew Little, Ashley Bloomfield, remembering that all of these people are honour respondents and none of them have done anything wrong. They just come to answer the questions of law that I have about the 1688. So we can consider this to be we can consider this to be right. We've got Norman here. We can consider this to be a small win. So it's not, it's not a win, but it's just saying that the court's working with us, and it's saying that we're working with them, and that they're understanding what we're saying, and we're understanding what they are saying, and everybody is acknowledging at this point that we exist. And that is the main point, because in the beginning, nobody wished to acknowledge that we existed. And this is what the problem in the High Court was, that the Crown Counsel had basically said to me, you don't have a lawyer, and therefore we refuse to engage with you in any way, shape, or form. And so they sent that to the court. The court sent them back to work with me for case management, and they still refused to work with me. They just said, we don't think that you have got any right to call the Prime Minister to the court for any reason, because you're not a lawyer, and we don't hear you, we don't see you, we don't acknowledge you. The appeal court said, oh no, you must come in, and so ordered them all to come in. But then we got hit with all these fees. Now the filing fee is $1,000, and I'll just put it up here so everybody can see one more time about the filing fee that I put up. Hang on, I'll just put the original filing fee. So I'll share that for you. So can everybody see that? Right. So the original that Miss McGrath turned me down for my application of a fee waiver of the $1,000. So I appealed that, all right? And then while we're waiting for that, I said about the $7,000, and I asked for it to be deferred. And I said, I'm requesting the deference on the possibility that the judge will answer a point of law pertaining to the 1688 Will and Mary constitutional law that I'm not clear about. And I used that it is the right to petition, that it is the right of the subjects, which is us, to petition the king, and all commitments and prosecutions for such petition are illegal. So that is what I've said to them, is that as long as you're using that 1688 Will and Mary, they shouldn't really be permitted to order you to pay fees. Because if the Parliament didn't make a law that was repugnant to the 1688 in the first place, then you wouldn't need to be going there. And if they've accepted your case, and they've said, yes, we accept your case because your cause and your prayer were acceptable to the court, then obviously there's possibly a reason why you're going to the court to question their law that they made. And you shouldn't have to pay for that, because they're not supposed to make laws that are repugnant, because it is in the Cabinet Manual, the rules that they have to follow. All right, now we've got Not Norman here, so we'll see if Not Norman wants to say anything.
Yeah, bloody awesome, Kate. I'm really impressed with what you're doing. I think you've cracked it, mate. I really think you do. I think there's, I've looked at all these other things and what I've been doing and following, and I looked at that Muldoon and Taylor case, and I looked at that Arthur Allen Thomas case. Yeah, mate, I think you're really barking up the right tree here, and I'm rooting for you hard out, girl.
Yeah, well, they've been blocking thousands and thousands of people from the common law. If you listen to all the common law people, it makes sense what they're saying. All the things that they're saying are fact. But unfortunately for them, the written law has been hidden for so long that they knew in their innate being of self that they had these rights, but they didn't know how to exercise them in a court of law, because they were going to the court of law and the courts were saying to them, we're a corporation and we don't recognize you without a solicitor. And they couldn't afford a solicitor, so therefore they were thrown out of the court on their common law. Now, they can do that in America, but they can't do that in our common law countries. Not all countries are common law. Only, there's only England, Scotland, Ireland, Wales, New Zealand, Australia are the true common law courts. The other ones come under different legal system. Even the Americans don't come under the common law court unless you're a state that's still under the Commonwealth. So they were throwing them out based on that. And then even when they were getting into the court, then they let them get to the appeal. They throw them out in the first, they appeal, and then they get them with the fees. And what our goal at the moment is to hope for, we're 2.5 weeks in, and we haven't had a ruling from the judge. So I'm thinking, yes. So I'm thinking they're thinking very, very carefully about what they're going to write. And I'm thinking that it's going to be significant. Who wants to speak? Who's got the whistling?
Billy, it's my bird.
It's your bird? Billy? You've got a bird called Billy? Who gets a bird called Billy? You don't call your bird Billy. You call your bird Tweet or something, not Billy. Birds don't get called Billy. Billy, like Billy Goat. You get a Billy Goat.
He's Billy the bird.
Who ever heard of Billy Bird? Billy Bird.
He's a noisy little bugger.
Well, he's noisy. Right. So now where am I up to? Talking about birds. I'm a bird. So I'm thinking that the court is going to be, it just seemed to me, because I've seen several other cases that have gone through, and even my own case where we got the ruling within a day or two. And usually it's pretty clear cut. They're just saying, no, off you go. But it's been 2.5 weeks in now. And
Billy.
Tell Billy to shut up, or I'll be putting Billy in the oven in a minute for dinner. Billy breakfast or something. Okay, so I'll put this bit up here. I'll just put this bit up here for a minute so you can see. We didn't actually challenge them for my $1,000. We pulled a bit of a Swifty here. Well, I did. Are you still there? Can you all see me? We pulled a bit of a Swifty here in that. Right, I'll just put it up here so everyone can see. Now that Not Norm's in here, he's quite a clever little bean. So he'll be able to look at this and help us. I think have you been doing this for a few years, haven't you, Not Norm?
Yeah, I have. Yeah, I've been doing workshops on common law and jurisdiction, sovereignty, rights, rules, regulations, acts and statutes for about the last decade. So, yeah, I've been in the circle for a wee while. And as I say, I'm really impressed at the angle that you're taking here. I think you've stumped them a wee bit with, questioning the fees aspect of it. I think you've really got them a bit stumped there because, that is one of the biggest obstacles we've had of getting into the courts is because the fees are so discriminatory that none of us can afford to get in there. We're all on the bones of our ass anyway. So, I mean, it's, beautiful. I'm really following closely what you're up to here, Kate. Awesome.
They can only rule one way. They can only rule in favour of Kate by law.
Yeah, it's a statement of clarifications, really, all this declaration is. And once you've got that, well, it opens the doors to all sorts of other things, doesn't it?
Mm-hmm.
Well, we know that they've been blocking you in two areas. One is the corporation aspect, where they're saying that the government is a corporation. And I've figured out, I was trying to figure out what all of you common law people have been talking about for decades. and I'm just new on the scene, and I couldn't really understand what you were all talking about, this corporate. I still don't understand it. But all I know is that the corporation bit is because the country belongs to us. And so the country is a corporation. And what I figured out is that whenever you're going to prosecute them, where it's possible that you can get money back, that you can prosecute them back, in that area, you have to have a solicitor. So if I was to win this case and I was to want to go and sue them for money, I would then need a solicitor. You can't go without it because the country is a corporation, and their duty as the caretakers of the corporation is to block or to reduce or to manage any person that's going there to get money out of the corporation. So I'm doing it on a different tactic, in that I'm questioning their points of law in some of the laws that they've made that are repugnant, such as removing us from the Queen, or removing us from the Commonwealth, or there's many other things that they're doing to us. And so that is a different area. If you want to go and get money from them, you really would not be able to use this. You would have to have a solicitor. But on the good thing is, if you go to the court on this one, and if you get a declaration about a point of law that has affected you, you then take that declaration and you interlock it, and it directly can go towards your case, and you need a solicitor at that time. But at that time, you're going directly for the jugular to get compensation for what you've been affected by. So you have to kind of go round the outside. But so that's where I think there's a lot of confusion with the common law people, especially like the health thing, because under the health thing, they're trying to get compensation for these injections. So whereas I'm seeing it on a different tactic, because I'm more about, that could come under cruel and unusual punishment and forfeiture of person without conviction, where they're forcing you to take your body and do something. But if I was to get that, and then I could say, okay, so we're not under your Health Act and you can't force me to have these injections. But if I wanted to go and get money, then I would have to get a solicitor for that. So I think, what do you think about that? Not Norm?
No, I don't actually agree with you, because each and every one of us actually does have a corporation. See, there's a maximum of law that states quite clearly that there must be equality before the law. So that means that they must be on equal footing. And when you've got a corporation known as the Crown, that's got all the money and all the lawyers and all the experts and everything, trying to fight little old individual me, there's no equality before the law. But what they do is it's a sleight of hand. At our birth, they create what they call a person, which in legalese is a corporation. So in actual fact, we do have a corporation. It looks like our name, sounds like our name, but it's not us, because we didn't create it. But they created it for our benefits to be able to operate in commerce and on an equal footing. And that's how they're getting us in the courts, is because they call out that full capital name, which is a corporation. Okay, so that's how the Crown can attack an individual, because they create that corporation that we then become joined with when we admit to the name, the full capital name. So I would disagree with you there, but once you get your precedent, once you get this declaration, I mean, that just opens up the door for us to test all this stuff. And we can do it through that avenue, man. It's beautiful.
Well, that is the point. That's what I'm saying. I'm not saying that you are right or you are wrong, but what I'm saying is that you all should be permitted to get into the court to battle what it is that you want to battle and get your answers back. That's what I'm saying, because this is where all the confusion is. Because by they're blocking you all into the court, there's no sound reasoning given to you. At least if you go into the court and you present your case, and then they come back and they give you a written reason why you're wrong, and then you can take that and you can whittle that down to what you think is correct and send it back, and they can whittle it down, and you can go to battle in a proper court of law with proper lawyers, proper solicitors, and you can clearly see when they're BSing you. You can clearly see it, and they can see it, and so it's there for everyone to see. And that's what I'm just saying. I just feel so sorry for all the common law people that seem to be, the most clever people that you could ever know. They might not have their law degrees, and they might have only finished, I've only got a high school education, but we have this belief in our soul that we have this innate law that belongs to us as a person. It doesn't belong to them or anyone else, and we believe that, and we want to have opportunity. They should have opportunity to go there. And it's not an issue of whether you win or lose. It's an issue of having your questions answered. Or if the court can't answer you, they can put it they're allowed to put it in the maxim of law. They're allowed to put it in the too hard basket. And they're allowed to say to you, on these points, we don't have the answer for you. This is the system we've got. And we try to work, and we don't have the absolute, because, it's just like medicine. They don't have all the answers. I mean, they're not gods in there. Nobody's got all the, so, but at least if you have the answer from them that says, we see this question of yours and we don't know the answer to that, I think you can live with that. Could you live with that or not?
Well, not only that, but it might give you the opportunity to attack it in a different angle. If they say, well, we're not going to give you this decision on this particular question stated as you presented it, then there might be other ways for us to go around that and come in the back door, if you like.
Well, that's what happened to me in my case, because unfortunately, which country are you from, not Norm?
Yeah, I'm a Kiwi. I'm here in Nelson.
You're from New Zealand, all right, you're a New Zealander. Well, I know what's going to say. So I had under the 1865 Native Rights and under the Germanic Settlements Act, under that, it only said that we were subjects of Her Majesty. And some people like me look at it that, this is in my Kate Floss mind, that we are the Majesty. And each one of us owns our own crown, and each one of us is the Majesty. And so when they say that our rights are with the Majesty, it's meaning that it's with us, and we are the Majesty. But unfortunately, when I put in my case, I had asked for a declaration to confirm the 1688 Bill of Rights under Her Majesty Queen Elizabeth II. And their battle to me was, you can't use Queen Elizabeth II. And I realized that they were right. I should have just said Her Majesty and not Queen Elizabeth II. But that's exactly what you said to me, is if you've given them that question, then they can come back and say no to you and explain to you why. And you can come back with another question of the same, but just reformat it. And to settle, because this common law thing has gone on for 30 or 40 years now. It's time they opened up the courts, don't you think? So yeah, because what I'm thinking is that if we can open up the courts, that people like you are going to have the opportunity to get into the court, and people like me that don't have the smarts. I would never be able to battle this in court, not in a million years. But people like me that don't have the smarts can watch what you're doing, and we can learn from it ourselves. And see that Parliament that's sitting in there, the Parliament is nothing. The Parliament, all they do is write bills for us. That's all they do. And it's the courts where the rulings are made and the declarations are made. And when the judge when the judge gives the like a court ruling, it's only an opinion. 4 different judges can give 4 different opinions, and they can each be different. And so they're only for citing and using as a precedence, right? But when you go and get a declaration, that declaration can never, ever, ever be changed, ever. And so that's why I'm saying, well, I'd rather go straight for the big time and get a declaration to say that our 1688 right exists. Well, it depends if you, and a lot of people are against the royal family, but I'm saying the royal family is just a shelf that we sit it on, and we have their armies, and when our parliaments and our courts go rogue, it's just another avenue that we can call them in and get them to come in and look over it for us. So I'm kind of in a different world here, I suppose. I know Maxine, can you help me out here? What am I saying?
No, I don't think you are at all, Kate. No, I think you're right on it. If you can get the declaration that the 1688 Bill of Rights stands first and foremost in law, then all the things that are decreed within that document then can be actioned. And for example, the fact that we've got over 60% of our women, representatives are foreign entities.
Yes.
Correct. Yes.
They're not supposed to be in there.
Let's concentrate on that declaration and getting that declaration, because once you've got that, man, everything else just is going to fall apart upon it.
And
I totally agree. I totally agree. That's what I've said all along.
And it's over 2 weeks. They haven't come back, and that tells us that that there's something that these are the stoppers, and we may be hanging on to a thread now. When Kate talks about the Majesty or the Queen, say, and which is England, it's a royal family right now. That the shelf, that those documents that they can't answer, and we're over 2 weeks, wouldn't be sitting there, would be meaningless without the shelf, without the Majesty. And that is why, like, I see people saying, oh, the Queen did this and the Queen did that, and Kate has tried to explain it, but it's like, you take away those documents. Well, we think those documents still cannot be taken from us, because then that shelf moves. It gives a direction within the 1688. Then you go to the Queen of Denmark. So that's what that is. And obviously, whatever Kate, what Kate put in, it's over 2.5 weeks. I mean, this is a reserved decision. That when they hold off, the longer they hold off, and when they come back with a decision, and hope to God that they follow the law, because it's the law.
I'll tell you what they're doing. They got like 50 people in the background working on this.
Well, I'll have fucking more than that. I'll be over in Westminster fucking having a big discussion as well.
Yeah, Westminster will be talking about it.
Yeah, they'll be talking because they can't get out of it. And this is what stopped the UN from coming in and taking us. We're holding on to a thread.
Yeah,
we're holding on by our fingertips. And those documents, and Kate talks about the chiefs, like, I understand why Māori and you go back to pre-1840, I understand why there's that, and it will never heal. There's, but because it doesn't, that's the human condition. But something happened back then that gave us these documents that we're holding on by the fingertips today. And you can't tell me that Tamati Wakanene and the people that he dealt with the colonists, as they seem to call them, you can't tell me that relationship, that there wasn't a relationship, because those documents stopping, are fucking stopping them.
Yeah.
And they can't give us a decision yet, and it's bloody amazing. But we also, I was thinking too, we need to keep an eye on the proposed bills, because they will find a way to fucking shove something in there and do something overnight. I'm,
That's what they could be working on.
yeah, that's what I'm thinking. So we need to keep an eye on that.
Doesn't matter. Doesn't matter, because once you've got that declaration, mate, that dissolves everything that they've got, everything else built on.
I'm thinking,
Actually, mate, yeah, it's the Achilles heel, mate. Once you've got that, and that's why they're taking so long, mate. They're shitting their pants. They don't know which way to turn at the moment, because they know what's hinging on this decision, and it's big. It's big, man.
It's true. It's a bit of a fight between the courts and parliaments as well, because one wants power over the other. So they're having the power shifts up there as well.
Well, at the moment, the judiciary's holding the legitimacy of Parliament in its hands because of what they've done.
Yes.
It's never been done before.
Yeah, not like this. No, there's been inklings of it with the Taylor case and the Arthur Allen Thomas case, but you've just taken it to the extreme here, Kate. You've gone for the jugular, mate. I love it.
Because there's been a battle between between the court and Parliament for hundreds of years over who was supreme, court or Parliament. And because they said Parliament is supreme over the courts, that they've got parliamentary sovereignty, but the courts have been saying only to a certain point. Once you make laws that are repugnant, then you're no longer supreme. And so this is the first case where we're coming in and saying, no, you're only supreme as long as you keep yourself in check and do certain things and follow. And so this is going to be, that's exactly right what Norm says. It's a battle. It's got nothing to do with us. It's a battle between court and Parliament, and we're not even in it. We aren't. Eh?
And whether or not they like it, because reading the challenge for change, whether or not the judiciary wants this, it's too bad. She's throwing them a curveball, and they've got to make a decision. The power's in their hands. If they want to take this back, if they want to take the power back, this is their chance. And hopefully.
It doesn't matter if they don't take it, because if they don't take it, well, let's just remember we're in a bit of a good position here, because no matter what happens at the $1,000 one, we've still got the $7,000 one, and then we've got the $2,000 one. So we've got 2 more cases, and then we've got the original court case appeal. So we've got 3. We've got 3 more cases. Whatever we learn from this one, whatever the decision is, we're going to be able to jump directly, because I've already written up the $7,000 one. I've already written that, and I've already added a whole bunch more stuff ready for them. I'm ready to strike. And so whatever we will learn from that, we can throw it in the $7,000 one. And whatever we learn from that, we can throw it in the next. So we've got, out of the one case, we've ended up with like 4 cases. And so, and we're going to learn from each and every one of them. We all are. Now, let's read some of the comments from some of the people. So, and how did you manage to get in here, Norm?
Oh, I saw one of your videos earlier on. You did earlier on today.
Yeah. Did you go in there? Did you?
Yeah.
Was that from?
Supposed to be. Sorry.
Was that from the YouTube, or was that from the Mary Pian's channel?
No, YouTube channel.
From the YouTube. Okay, all right. So you managed to get it. So yeah. So
Norm, I was asked by a friend she's getting quite deep into the common law stuff that you're involved with. She asked me if I would go and have a yak to the common law people in her area, which is my area, and that her common law coordinator told her that no, they don't want me there because that they're up to date with it, and they cannot be up to date with it because they have no clue.
That's right. You know,
I seem to see within the common law community a lot of infighting and power struggles.
Our egos, mate.
Yeah, egos.
Everyone's trying to get their little piece of carve out their little piece of the pie and make.
I went up to Granity 2 weeks ago and spoke with the South Island Independence Movement guy, and there was about 20 common law people there, and it was really good. They were really, like great to talk to, and they were really interested in what I had to say, and
awesome.
And I just talked about Kate's work and how things are progressing with us, that we've gotten probably further than anybody else has.
Yep.
But yeah, them egos, boy.
There's a lot of egos
Yeah.
going on. Everybody wants to be the one. It's just sad. The thing is that it's sad is because people have worked on this for 30 years and there's no one person that has discovered everything. It's been people that have worked for 5, 10, 15 years, and then someone's come along and looked at their work and said, I've got an idea, and they've added an idea. And it's just very, very unfortunate that through all of those decades of work, hours and hours of work, then they never got paid a single penny. And then to have some people coming in, just turning up, leading the way, and they feel protective of all their work that they've done, and some of them feel or don't want to be feeling like they're being shoved aside. And I'm not going to say I feel guilty. I did 2 full years of research every single day, hours upon hours, and I went right back through all the New Zealand history. I did the French history, the German history, the English history, the Irish history, the Scottish, the Australian. I went through the whole lot. I made videos on every single piece of it. So I'm not just but I am a Johnny-come-lately, but I'm not going to say I'm feeling guilty for getting in the court, because my goal is to open it for all of you. But I don't want to be I'm not in for any ego, and I don't want to be the leader, but I just want to stop them from doing what they're doing to you all. For all the hard work, you should be allowed to go to the court and present your case. And so, but I do feel a bit guilty about that. But I don't see any way around that.
You shouldn't, for the fact that in your 2 years, the emotional impact, that even with me being with you, the emotional impact of this has been horrendous. And how we've done the hours, but we've learned things that are really, really hard to sit with, to think that this has happened in our country, and these people have done this to us, have come in, and people that we thought that should love New Zealand and want to keep it safe for all of those that date back to the first peoples and the first ships, and yet the whole time they've been wanting to come in here and just take everything. That journey alone has been horrendous. Like the emotional side of it's been like crawling through glass with these things. It's
not to mention all the hate that's been thrown your way.
Yeah, and she did most of her stuff alone. And the only reason I came in and listened to her was there's this little white lady on YouTube mispronouncing Māori to the max, and how she presents her information sounds totally racist. And I seen her and I thought, oh my God. And then she just kept going, and then I thought, I can't listen to her, and went to look for somewhere else. I had to come back because she's the only one that was talking any sense. And her way of doing things, but she kept asking for help.
Yeah,
kept
wasn't
I,
it?
I asked for a long time and nobody would come.
Yeah.
And the little team, now we've got Norm's come, but nobody would come, would they, Maxine? But I did
No,
ask,
and I kept
everybody
seeing it
called me
calling
mad
out
as a
that. I said,
hatter.
oh my God.
Yeah, they all said you're mad as a hatter and we don't want anything to do with you. But now we're getting results because we persevered, didn't we? But hey, let's look at these people here. I just wanted to say, so we've got Betty Ford. Betty Ford says what happened. They have to cause that is lazy not to answer. Betty's saying they're lazy not to answer down at the court, but I'm not sure about that, Betty, because I think they would have to be extremely careful how they answer this, because whichever way they answer, it's going to affect Parliament. It's going to affect all of us, whether it's yes or no. This is going to have a huge effect. So I think they would have to be extremely careful. But I'm hoping that we might get a declaration right in the first bit. We put up, because I put it up here. I'll put it up here so everyone can see. Did I put it up on the 1688? So I'll show it to you, the one that we used. And you all know this, of course, but I'll put it up for you so that you might, I would encourage you, Norm, if you do make any cases, to put this one up here anyway. And so the one that we used here, and now you cannot, I'll just tell you, you cannot use this with subordinate laws. So the only time you can use it is when there's a subordinate law that's repugnant to it. So you can't be using this with that 1990 workers' rights thing. So, so that's why a lot of them are failing, because they keep using that. But I've used this one that you see here. It says right to petition, and I'll put it over here to make sure everybody can see. So it says here that it is the right of the subjects to petition the king, and all commitments and prosecutions for such petitioning are illegal. So that means all commitments, that means all forcing us to pay money would be illegal whenever we're petitioning this law. And not only that, if we refuse to pay that money, if they give us a bill for going to the court and we refuse to pay, it says that it's illegal for them to prosecute us for that. So we get a double whammy here, all right? And then, so I'm not going to go too much into that, but so they're being very careful, but I will share here just to show everybody that when I petition this case, I will just tell it again so some of the new viewers will know here that I didn't actually use my case to do it. This is the funny thing about the whole thing. I'm not, see, here's my $1,100 that they wanted me to pay, all right? And don't worry about any of this stuff here that I've had to pop. Don't worry about that. But there you see that I've put that it is the right of subjects to petition the king, and I've added to that and or success of majesty, and all commitments and prosecutions are illegal. So I've said that to them. But I didn't use my case. I said to them that this is called a book called Challenge and Change, Judging in New Zealand, all right? And then this was contributed to this was Justice Winkleman and Justice Cos, and from the LexisNexis, which is an American law. And they had put in the Fitzgerald case. And this is what they said in the Judging in Aotearoa in New Zealand. They said, a humble young public servant thought that a law was wrong, just like me. He stepped forward as no one else would, just like me. And no group was prepared to stand alongside him in the trench, just like me. And then the fee, he was charged with $3,000 or $23,000 in today's money, which was more than half of his salary. And then I said, then I've thrown it back to them and I've said, his case, even though it was calling the Prime Minister to account of a violation of his right, under S1 of the Bill of Rights had garnered no public attention. So they said to him, even though you won the case, nobody in the public was interested. And since nobody in the public was interested, you're still going to have to pay for it. See, this is where all the common law people are in trouble, because it doesn't matter if you win or lose. You're going to pay anyway if it's not considered to be in the public interest. But many of the public don't know about these dangers in their laws. And so Fitzgerald...
Easy to argue. It would be pretty easy to argue that point, though, Kate. Seriously.
Yeah, I have. But no,
how is it not in the public's interest that they're abrogating our laws? I mean, that is
Well, in my first case, right down at the first High Court, that when the Crown charged me the $2,700 lawyers' fees that they charged me for that case because they'd said I lost it, he said exactly the same in the public interest. He said, oh, even though constitutional law might be something that the public might be interested, it doesn't seem like they're too interested in it right now, so I wouldn't consider it to be in the public interest. But why would not constitutional law? Of course it would be in the public interest when they're violating it.
But here's the thing, Kate, you know, they're not going to give anything away willy-nilly. They're going to make you work for it. So they're going to challenge you, and they want us to be worthy of the rewards that we're going to get. So they're just not going to give us, they're not going to tell us the truth. Okay, they're going to use deceptive language. They're going to use little potholes and tricks and that to try and sidestep us and get us all confused and not knowing what's going on. But you've just got to persevere there, girl. I think you've really got them on the back foot, mate.
And the other thing.
Oh, Sharon, your microphone, Sharon.
Turned off.
Sharon, microphone.
Microphone.
How can it not be in the public interest? Because everybody would be interested in Jacinda Ardern and the others.
Yeah.
How can it not be in public interest?
Exactly.
First and foremost.
And let's also not forget that, you know, the Fitzgerald case was in 1976, and now the public is showing interest in it in 2022. You know, let's not forget that. There's interest.
The Muldoon.
Well, they're standing outside. They've been standing outside the Governor General's gate, knocking on the gate for months, which to no use. They've been standing outside Parliament getting beaten up to no use. So of course it would be in the public interest just having Jacinda Ardern, and the people have been saying we want to have something. We want to be heard. We only want to be heard. We don't care what the outcome, but we want to be heard. Of course it is. And then that's exactly right. You see, that Muldoon case, because I put that, they've been using that in the law schools for 30 years now. They've been writing every single law book that they write. His name is in it. So I said that to them. Look here what I said to them. So I haven't asked them to look at my case. It's actually quite sneaky because I got them to go back to his case. So I have challenged his case, not mine. So I said that he had to pay because they reckon he had garnered no public attention. I said, here we have a singular person with no substantive public backing wishing to go to the High Court to claim his right to question the validity of a law or announcement of the Prime Minister Muldoon. So this is what we all want. I claim, that's me in this present day, that Fitzgerald should never have been charged High Court fees. Under S1 of the 1688 Bill of Rights, the right to petition, all commitments to the court or the state are illegal when petitioning for a declaration of right in this 1688 Bill of Rights, Will and Mary. So I have put this back and I've forced them to go back and look at a 50-year-old case to see if they did wrong to Fitzgerald, and I think that they did. I also claim that in S1 of the 1688 Bill of Rights, subjects arms, that the subjects which are Protestants may have arms for their defence as allowed by law. And I've said, and the arm of our defence of Protestants in the common law is the unobjectionable right to pray for a declaration by the court to affirm their right. So I'm saying that they should never be allowed to object to us going to the court to ask about our right. So then I said to them, the Fitzgerald case was deemed to be of little public interest, and yet here we are 47 years later, still reliant on his case because he's the only case in all New Zealand. The registrar may not see significance in the present day, but the significance to the public of my case may evolve exponentially to the public and Commonwealth over time. So I've said that when a question of repugnancy in the law has caused fear, everybody's afraid at the moment. Don't tell me that we aren't. To such person, to the extent that a desire to petition is deemed necessary, then such petition must be free of commitment to the said petitioner, and the lawmakers must be held accountable to the causation. They caused me to fear, so that they caused me to go into the court. So their court's going to have to address first the issue of if what they did to Fitzgerald was a crime in itself. And I believe that what they did to him was not correct. However, in saying that, he didn't call it, which is a pity because he probably should have. But anyway, he didn't call it, so I've called it for him. So they've been charging all of you. See, this is why they have to be careful. They've been charging all of you for decades based on charging him. And I'm saying that that is what has caused all of you poor common law people who've been fighting all of this headache all these years because you can't go to the court and you can't afford lawyers. And so you've been blocked from your right to justice. So this is a very sad situation for all of you. And it was that I was seeing, and that's what was upsetting me. And so that's why I wanted to find a way around that. Yeah.
See, that's a perfect example of what I just said too. You know, the courts would tell him that he can't do that and he has to pay. So he didn't question it, he didn't challenge it, and he just went along with it. That was his opportunity to be able to put in a rebuttal to their claim. And that's where we've got to be. We've got to be vigilant all the time. Anything they put to us, we've got to question it. That's what you're doing.
Well, he was happy. He was happy to get one win.
Yeah, sure.
And he didn't realise he could have got another couple of wins in there while he was at it.
Well, we don't know because his things were lost, weren't they?
He got the decision that he was looking for, but they turned around and made him pay for it, which is where they shouldn't have.
I mean his a lot of the what do you call it?
She's saying all his documents were lost or they disappeared. The only thing that survived, apparently, is the ruling. And they reckon that all his documents are gone. And me and Maxine are questioning if that would be true, because if I won a case like that, I would be wanting to keep those documents forever. So they're saying that all his documents disappeared.
Court's record too, so they can't disappear those records, mate. They've got to keep them there for public. You know, these are public decisions.
They kept the decision. They kept the decision, but all of his submissions were apparently left with his lawyer, and his lawyer apparently threw it all out or something.
And it mentions the fact that they are, nothing survived. in the Challenge to Change book.
Right.
But it was quite interesting that his solicitor did go on to have quite a good career afterwards as well.
Well,
That was mentioned in Challenge to Change as well. There's quite a lot of interesting things in the Challenge to Change books. Probably the best $150 I spent.
yeah, we're going to have to put up a video about that. I'll put up a video about that book and show it to everybody. Just so that's called The Challenge to Change New Zealand. It's a new book out. I'm not sure if we can put it up on the screen. I'll try to, Maxine, because we should pay homage to the book. But this is the fact here is, what's the book called, Maxine?
Challenge to Change.
Challenge to Change in Aotearoa, New Zealand. Where was that?
So we, the thing is that, well, all right, here we go. The thing is that we were saying, well, they said that it was not in the public interest, right? And yet here they are 46 years later writing books about it and collecting, because they want this book in every single law school in New Zealand, and it will be in the law schools of England. They will all be looking at this, and they've put in all these cases to cite from it. And it just is interesting to me that they are making money from his case, that they've said, this is what they said. They said that his case garnered no public interest, and yet here they are 46 years later making money off it. This is LexisNexis, an American law company, and it is LexisNexis. See, LexisNexis came to power in our country in 1972. And it is all these law changes have come through LexisNexis. LexisNexis is a brand new law company, and it took over the law company of Butterworth's in England. That the Queen Victoria's law and the Butterworths in England came to power in 1837. And right up until 1972, we used the Butterworth's law out of England. In 1972, LexisNexis purchased the Butterworth's Law Company in England. What's he got there? Ah, he's got it. Yeah.
New Zealand Butterworth's Law.
Yeah, oh my gosh.
Even the edition, but look at the bottom.
Oh, shoot.
Butterworth's, Nexus, Lexus.
Yeah,
Thing.
so the LexisNexis, well, the Lex stands for law and Nex stands for media. And so LexisNexis is getting paid billions and billions of dollars every single time that a case goes into court using the LexisNexis laws. They get royalties like the music business. And in my opinion, they've been creating chaos so that they can make billions of dollars off of the royalties. And so, but even so, LexisNexis took, they even took Fitzgerald's case and they put it into their book. And so they know all about his case. It's not like they don't know about his case. They took over the law company. And this is why we're having problems in England, Scotland, Ireland, Australia, and New Zealand, because they're not been following our common law. They've been following the American Constitution, which is very different, because under their Constitution, they can't directly go to the court like we're supposed to be allowed to. And so it's LexisNexis that's been holding this all up. But this Muldoon case was up front and centre in here. And so it was, the Muldoon case is key to it being used in the universities of New Zealand for teaching. But my point is that they forced him to pay for his case. He won his case, and now they're saying, and now they're putting his case into books and they're making millions of dollars out of it because his case is in the book, the most famous common law case of all time is in there, And then here I am strolling up to the court, and they've pulled the same thing on me. They've said, your case is not in the public interest, and you're going to have to pay that. We're going to let you have your case. You can have your case. Even if you win it, we're going to get paid. And I'm saying, and that's what I'm saying is that, no, if you have made a law that is repugnant to our common law, which we are all born to, then you have to be responsible to answer the questions that we have. And all you common law people know, they've got a duty to answer to all of you, because it only came in 1972. So you have the right to ask all these questions. Of course, you should have that right. And how dare they take it away from you? How dare they?
Well, the impediment's always been the financial hurdle for people to get it in there. That's what we haven't been able to get around.
Yes, well, I had contacted a guy in Australia. I wanted to take this case to the court, and I had contacted several guys, and they had said to me, you need $6,000. Some of them have said anything up to $90,000 to take a case into the court. And I was like, but as I've shown, well, the most it's going to cost me, even if I do have to pay all the fees, if I have to pay all of it, it's going to cost me $14,000. And my husband will give me that from his retirement money if I need it. But I agree
with you were saying it shouldn't cost you a bloody red penny, mate, because any impediment to get into the courts is discrimination. So what that means is if I've got enough money, I can get justice. If I ain't got enough money, you ain't getting no justice. So that's discrimination, and the courts can't operate like that.
Well, they pay for the New Zealand Maori. The Tikanga Law Society is all paid by Parliament, all of it. The Human Rights Commission and all refugees and all workers' rights are paid by Parliament. The only one that's not paid by Parliament is the common law, and the courts were originally set up for the common law, and the common law in the 1688 is in the Cabinet Manual, and in the Cabinet Manual it is saying that we have these laws, and they have been ignoring it and making laws repugnant because they had figured out this system knowing that we were never going to be able to get into those courts. They were always going to be able to block us. And no solicitor would take our case. Now, Maxine, I contacted the Otago laws because they kept saying to me, get a lawyer, get a lawyer. I contacted the Otago Law Society. And you know what? I discovered at the Otago Law Society that they have classes from 5 o'clock to 7 o'clock, somewhere around there, every single day, that you can go and attend classes with lawyers from the university who are in training. And they say on there, if they see your case as being something interesting, which of course my case should be, then they will take yours on as a case study, and they will work through it with you to get it into the court and get it all done. And they will do it all for you. Do you know what? They sent me a letter and they said to me, we don't do constitutional law, statute law. They said we only do advocate law or something like that. I tried to then they said to me, contact the Citizen Advice Law Society there. And when I went to contact them, if you're a New Zealand Maori, no offense to the New Zealand Maori, but if you're a New Zealand Maori, they've got a number that you can call directly, and the Tikanga Law Society will work, and you can go directly to the common law through to Westminster with them. And then they've got a migrants' right law where you can go, I think it's 3 days a week, and they will discuss with you any laws that you want to know about migrants' laws and about your visas and all of that. And it seems, but the ones paying for all this is us. And our law, our 1688, is right there in the Cabinet Manual, and it says right there in our 1688 that their job is to strengthen, amend, and promote our common law right. And instead, they've been promoting the human rights. The human rights is getting billions of dollars of New Zealand money to send, and they all provide the immigrants, the refugees, with qualified lawyers from the United Nations, while our own people are knocking at the doors of Parliament saying, let me in, and they have locked the door and will not let. I'm very angry about this, Norm, to the way that the New Zealand people are being treated presently, and Australia and England and Scotland, and I'm very, very angry. So
I think they've done us a favour by blocking us off, because like what happened to us when we got in to speak to the registrars, nobody knows about the 1688. They wouldn't even know that. They don't know it. So there's no experience there. There's none. And so they're all being taught about all the other stuff where you make money, and people are thinking, but they don't. So I think it's been a bit of a because we've had to figure it out ourselves, and who knows it better than you, technically.
And that's why I said the unintelligible ones were not us, because we understood everything. They didn't, but they put it back on us. So
And
that
they
was
just-
wrong in itself.
And the jurisdiction as well.
Yes,
Yeah.
yes,
They didn't understand the jurisdiction.
yep, exactly, exactly.
yeah,
In
Norm, you
fact,
want to say something?
Yeah, that they're not worried about they're not mentioning the 1688 Bill of Rights because there's no public interest. See, that's a play on words. When they say there's no public interest, the only reason there's no bloody public interest because no one knows about it. If they knew about it, man, the whole country would be up in friggin' arms.
That is exactly right. That's exactly what I was thinking.
They used
That's
to,
why that ruling should be null and void, because nobody knows if the case is going. If it wasn't for the
Right.
fact that Kate was doing recordings and videos, nobody would know. And of course they wouldn't get interest.
Yep.
But hey, 50 years later, they're making money off it.
And look, yeah, Kate's here.
Yes,
yeah,
yes.
look out, because I'm not going to give up, because I just love you all so much. The common law people like Norm, the amount of work you've done and the amount of hours that you've put in for nothing year after year, and I'm just wanted to do this to open up the court so you
Kate,
have your
no,
opportunity.
no. We don't do it for money, mate. We do it because we care about our country.
Exactly,
We care about our
exactly.
kids, man.
Yeah.
And we don't want our fenua being sold out from underneath our feet, mate.
Yeah,
That's why we do it. We don't
Yeah.
do it for money. We
No.
don't do it for fame or any of that bullshit, mate. We do it because we know there's something wrong and we're trying to find the remedy. That's it.
well, the sad thing is that this has always been something that belongs to you by your birthright, and they've been hiding it. And I think that's a deception. There's a deception when they're hiding it, because they brought out another Bill of Rights and called it the same thing. And I just don't think that they've been complete, because there's a thing called lying by omission. And lying
That's
by
right.
omission is still a crime in a court of law. And
There's also willful negligence.
yeah, exactly.
Willful negligence,
Yes,
mate.
yes.
Mate,
And
they're
when
in
they're
trouble.
and when you've got people standing on the Parliament, when you've got these common law people that have been sending letter after letter after letter to the Parliament, to the Governor General, to the police, to everywhere they can think, and they send you back letters saying, oh yeah, we've seen that, yeah, all right then, we have, and none of them are saying to you, hey, you've got this right here, and this is something you could, none of them. And I think that's a form of lying by omission, And I think that it's not what, I don't think that they have behaved in the way that government servants should behave towards you. And so let's have a look here. The next one says corporation, not cooperation. Everyone gets on me because I speak badly. Empressa from Royal House, Adele, says, the King's Court magistrate in London will always say its origin and jurisdiction, full stop. And a coroner to witness and sign off the declaration sits higher than any magistrate judge anywhere. Right, I'll read that again. Have a listen to this, Norman. I'll be waiting for your comments. The King's Court magistrate in London will always say its origin and jurisdiction, full stop. And a coroner to witness and sign off the declaration sits higher than any magistrate judge anywhere. What do you think?
Okay, I'm not too clear on what's being expressed there, but I would just go back to the maxim, first in time is right in law. First in time is first right. So, your 1688 Bill of Rights sets out the playing field and the rules and regulations from that particular point onwards. And that can't be, that's where the buck stops. The buck stops at the 1688 Bill of Rights, right? And that's it.
It is. That is where the buck stops. It says you can do what laws you want, but she's right. It says the origin and the jurisdiction. Now, the origin talks about, I assume that the origin is talking about where I suppose where you come from and where the laws come from. Okay, but what a lot of people don't know is that the New Zealand Maori, the chiefs Tamati Wakanene and Chief Patu Oni, not Patu One, Patu Oni, Maxine's laughing, Chief Patu Oni and Chief Tamati Wakanene. Tamati Wakanene, all right, I'll turn this off. Tamati Wakanene was a king in his own right. And a lot of people don't realise that because we've got many different factions of tribal factions that are saying, we're the right tribe and we're the right tribe. And that man in 1840 signed that and we don't recognise it because our tribe didn't sign. But Tamati Wakanene had in the first, his picture was on the first coins of New Zealand together with the Queen. And from my understanding, when money has got, in the old times, not the new times, in the old times, when money was first produced, it had to be backed by a king or a queen, because if the people didn't honour that money, it was the Queen's armies or the King's armies that went and gave them a hiding and made them pay up what they were supposed to pay up for the money. So when at that time, kings and queens were always on the money, and for Tamati Wakanene to be on the money, that said that he was a king. Now in 1865, he signed off that we would be under the Queen's law. And not only that, there were three ships that came out. There were three ships that came out from England with 5,000 people on each, and there were two ships that came out from Germany, and they didn't have 5,000, but also there were several people that were already living in New Zealand because the Anglo people had been living in New Zealand since around about the very early 1800s. So by 1865, even the 1700s, so they've been around for quite some time. Well, he put in that we would be under the Queen's law. Now, that document has not been repealed. It was done in a court of law, and it was done in, they already had the New Zealand 1852 Constitution, and it was done in a court of law, and one of the signatories to that was Tamati Wakanene, and he was a king. And that just said that New Zealand was going to be under the Queen's law. Well, the Queen's law is a forever document. But even if LexisNexis takes over the Queen's law, doesn't mean that they get to shirk the common law, our written common law. So we still get to keep that. And so it's like I'm saying that, we have a lineage of law. Law is not one document. No country is ever built on one single law. There's a lineage of law, and you have to follow the entire lineage so that you can see the intention of the people of the time and what they wished for it, because at that time it was their country, and they wished New Zealand to be under the Queen's law, and that the Anglo people and the Maori people would be together, but we did have separate governance. So they don't get to shirk. The only way that they would be able to remove this law is if they could get the descendants of Tamati Wakanene and Patuoni, and they got them to repeal the 1865 Native Rights Act and also the German Settlement Act. There were several. Mine with my ancestors has got the German Settlement, but there's actually several of those, and they would have to repeal that. Even then, I just don't think. I think it is the highest law. I don't think they can ever remove it from us, and so we should utilise it. And then, as Norm says, 60% of our parliament are foreigners, and that is against the law. And this is why we've got so many problems, because they're governing us according to many countries' laws, and they're forgetting that our countries, England, Scotland, Ireland, Australia, New Zealand, we all come under this common law here. Not America, and not even Canada don't. Even Canada don't come under it. So, and we just want people to get to know it. So, so that when we're talking about the origin, where did the origin of the Queen's Law and this common law come into New Zealand? Well, it was done under King Tamati Wakanene and King Patuoni, and it was also done under Hobson and Queen Victoria, and then also it was revamped when the kings passed and we got Queen Elizabeth's father. It was reconsolidated in 1908. We've got our lineage of law is the Declaration of Independence, 1835. Then we've got 1839 is the Queen's Law came to New Zealand. That was actually done on January 6th that we came under the Queen's Law, and it wasn't until September that the treaty came into power in New Zealand. It wasn't till September, and it only asked them to concur if they wished to be subjects of the Queen or not. That's all it says. We would like you to concur if this is what you would like to have. It wasn't even done in a court of law. It couldn't be done in a court of law. And the reason why it couldn't be done, because New Zealand, the English that came in were only a scaffolding government. They were not permitted to make binding laws to the New Zealand native people at that time. And so then we had that one. Then in 1852 is when we got our constitution. Now, all of these were done under the King's flag. That's the 5-pointer with St. George Cross and the 5-pointer. That 1852 was put in under the King's flag. So that had to have been done by the native chiefs. It had to have been done in agreement with the native chiefs because it was done under the King's flag. Then after that, Actually, the German settlement and many people, there were many different acts, so I haven't shown them today, where they removed the alien status of many people that came to New Zealand from Scotland, England, and Germany. They removed the alien status, and they also, if they cut the ones that came from Germany, they removed their German nationality, and they removed their alien status, and they planted them in the soil of New Zealand. And so then they did that one, and then after that came the 18th. So those documents had to have been done under the king, or the Maori king of Tamati Wakanene and Patuoni. All of that was done by them, not done by us. The 1852, and the 1852 is when we first had a constitution to create laws in New Zealand. So, and then after that, we had the 1865 native rights. You see, the treaty said we would like you to concur, to think about if you want to do this. That was 1840. It wasn't until 25 years later that, and Tamati Wakanene was still here, he was called the Waka. At that time, it actually went into a New Zealand court of law, and they passed a declaration that New Zealand would be under the Queen's law, the whole of New Zealand. Now, that's not ever been repealed. It sits there today, and I've used it. Now, that one there, that was done in 1865, still under the King's St. George flag and the Maori chiefs. Wasn't even done under the Queen's flag. The Queen's flag didn't come in until 1902. Yeah, that's when it came in. So that means that this lineage of documents were not our people, our Anglo people must have been, of course, they wrote it, the Queen's Court wrote it, and the Imperial wrote it, but the ones that signed off on it were the native kings, not us. It was done under that Whakaputanga Declaration of Independence flag. That's what it was all done under. Not under the Union Jack flag. That came later. Now, so 1865, that was when the chiefs decided on the Queen's law, not us. They did. Now, in 1908, Queen Victoria had passed and the kings had passed, and Queen Elizabeth's father came to power. And it was in 1908, after 1902, we got the Union Jack flag. And then in 1908, we had the Native Rights Consolidation Act, which only referred to New Zealand Maori and their lands. So that was a separate document done with them. But it did include the 1865 Native Rights Act. The 1865 Act says that we're under the Queen's law. So LexisNexis, that was done in 1908, right? And LexisNexis comes in 1972, so maybe 100 years later. So none of these laws have been repealed. So I'm not even wanting to deal with their modern day laws because they're all subordinate. But these laws here are not. These laws here are in stone because they were made by declaration, they were not made in Parliament. They were made by declaration in the court. And that's why I'm saying to all the common law people, forget about the Parliament. The Parliament is just I don't know what they are, but they're not what you think they are. They just, all they do is, eh?
Clowns.
Hey?
They're the clowns.
Well, they're the clowns. They're the clowns.
Window dressing.
Well, they're window dressing.
The distractors. Clowns.
No, well, you vote them in and you tell them what you want in your country and they create the bills for you. That's all they do. You vote them in and they do their parliamentary manifesto and they say, this is what we're going to give you. We're going to give you this, going to give you this. And if they get the most votes, and then when they go into the parliament, they write all the bills for you. They're just the bill producers. They're like the, when you own a school, right? And the school is yours and you've got an administrative office. And the administrative office sends out the bills to everybody and everybody comes and pays it. And then they take that money and they buy some stuff. That's what Parliament is. They're the bill makers to give you the things that you've said that you want to have. But as the court, if you go and you get a declaration, and those declarations, you've got a hell of a job overturning them. I've never seen one overturned, quite frankly. So this is where I think that we need to go. So this is why they're talking about origin and jurisdiction. And so when we originally bowled up to the court, me and the Oreo team, because for 50 years they'd been looking in the jurisdiction of the Parliament, they didn't recognise me. I don't think they quite saw me. And so they said,
They didn't see you coming.
No,
No.
they didn't. They didn't. So they said you've got no jurisdiction, but the appeals court said yes, she has, and you better get in here. And so then, but anyway, that we said to Maxine, if they only had said to me, here's the declaration. Yes, the 1688 is the law, which we know that it is because it's already there. They only had to write this little thing and say, yes, it's the law. And I would have gone on my merry way. But instead, they got cheeky to me. And so now we're going to have 4 cases instead of 1. So we're going to have 4 opportunities to get 4 lots of answers.
What
So that's
happened
great.
really, and what got my goat was people in those positions within the court offices who English is their second language were quite rude and very dismissive and condescending of you. The judges were willing to listen, that's where that just did my head, and I thought, how dare you walk into our country, take those positions, and then our documents, because we believe in these documents, and then you treat us like that. So yeah, they you can't help wondering that these English as a second language, is specifically put in there to stop. But we got past that. It's like being a gatekeeper, and then you got to get past. But like you say, we are trustees of our company, of our country. They work for us. Like the government, Parliament are put in there by the people for the people. They work for us. And yet we have to jump these hoops just to get some answers. That's wrong.
I laughed today because I was watching the news. I don't watch the news often, but I was watching the news. And today was, back in history, was the day that Maori became an official language of New Zealand. Now, they failed in their great reporting to communicate to the people that Maori is the number 1 language in New Zealand now, not the number 2 language. It's the official language of New Zealand. They failed to state that. They were saying that, today in history, Maori became an official language, not the official language.
We have to do a whole video. That it's a huge point. And if you can keep that there, because we have to do a whole video on that, because there's laws about that they've broken as well to make it. So I don't want to go into it now because it's a whole video that we're almost 2 hours in, but save that up because we are going to have to do a whole video on that. But there are laws, but we won't do it today, Brent, but keep that that little piece with you, but we won't do it today. But that's right, they've made Maori as the first language, but we've actually got the declaration where they went to the court and they got a declaration to say that English was their national language. And so they've pulled a Swiftie on us with that as well. So, and there's reasons why they're doing that, but never mind, we're not go there, we'll get this first one. The coroner to witness the declaration sits, it's true, the declaration sits higher than any magistrate or any judge in the entire world, if you can get one. And that is my point. Thank you there, Adele from Royal House. That is the point. The point is that 1865 declaration is higher than any parliament, than any tikanga law society, than any you or me or judge or president or prime minister or LexisNexis. It's higher, and until they take it to the court and have it legally repealed, which I don't think they can, but if they could, then until they've done that, then it is higher than all of them. And so we'll have to wait and see. And Bon Patrice says, and so say all of us. Yes, it's so say all of us. That's right. And then Cyril Gold said, feeling what? If we're feeling happy. So we're going to probably end this session now. I like to stay around because I could sit in here for hours with you. But let's see if anybody wants to say anything about what's going on. I've said all I want to say. What do you want to say? Anything, Norm?
You know, all these obstacles, again, I just want to reiterate that point. Those obstacles are there because the goal or the result of what it is that you're going after is extremely valuable. And so they're gonna frustrate you every step of the way. So as long as we have that mindset, then anything they put in front of us is just a challenge to us and it helps sharpen our teeth. So, you know, don't be put off in any way because they're doing this stuff to us. And in fact, it's an honour. It's actually a badge of honour that they're frustrating us so much because what we're going after is so valuable. So,
no, we want them to put up. We want them to put up as many obstacles as they can, because if you have success, even with all the obstacles, it's going to be very hard for anybody to take down any success that you get. But anything that comes easy can easily be changed. But things that come difficult, if we check every nook and cranny, and that's why I said that this is a great case, because we've got 4 more cases to come after this, you see.
Yeah.
So
you're just getting warmed up.
so if they come back with something here, this is going to be great, because we've got the next one where we can, because we're all very resourceful, aren't we? We'll be able to come back and come back. So, and then then it'll get refined down. And I have no doubt that we're all going to get something, including the courts, including Parliament, including all New Zealand people, the English people. All of us are going to get something. So we really don't want it to be easy. And if the answer is no, then we want an answer no, and we want to know why. And they have to tell us why. And it's those points that we as ordinary people can learn from, and we want to learn, and we should be permitted to learn about these important things, because it's for your children. It is exactly like you say, this is for your children and your children's children and your children. God forbid that even if the protest did win something, even if anybody did win something, this is just going to keep occurring again and again and again. And your children, you don't want to die leaving your kids with this. I don't have children, but if I had them, but I've got relatives in New Zealand, and I don't want to die leaving them with this to deal with. So, but Maxine put a good point, is that down at the court, we had put in an appeal about something. I had asked the clerk for his phone number because he couldn't speak. Wasn't sure if he was a native English speaker. So I thought, I'll call him at the court. It'd be easier if I talk to him and we won't have this cross communication. He refused to give me his number, so I asked for the case management, and they refused to even speak to me on the phone. And I thought, well, you're getting how much are they getting paid a year, and they won't even speak to me on the phone? And so that's what caused us to go to the appeal, because we weren't going to go, were we, Maxine? Maxine had said to me, Kate, don't go to the appeal. We were going to do a whole new case. We were going to dump this case.
No.
Were we going to dump it?
No.
We were debating. It was in the last minute. But
we couldn't even get it down.
They wouldn't even let me talk to them on the telephone, and we were like, wow, if you're going to be like that. So yes, we want it to be difficult. We want it to be, we want them to put up as many walls as they can put up, and we want to knock them down if we can.
I don't think they expected you to frustrate them. And I think that's why it's taken so long for them to answer, because they're totally frustrated.
Or the other thing is they're stalling.
I think
they're stalling.
They're expecting once we got struck out and that by that Justice Cook, no, it wasn't Justice Cook, was it?
Yeah, it was Justice Cook J.
Oh, no.
Francis.
Palmer. Once we got struck out by Palmer.
No. Palmer. When we first went to the first court management, if you let me finish, we went to the first court management. They asked to strike out, and they refused to bring the respondents. And Palmer J, and they said, we want you to rewrite your entire claim. Now, to all you common law people, be careful about that, because we had already passed court process, and then some people have been told to rewrite their claim. And when they rewrite their claim, it's the new claim that didn't pass the court process, and they they didn't even get into the court because of that. So when they told me to rewrite my claim, I said no. I said I'm quite like it. And so Justice Palmer put in his thing that Miss Sixtus thinks she did quite well with her claim and she doesn't want to rewrite it. And so he said to them, you will defend this case. And so then we went away, and they were supposed to do case management and sort out the days and sort out everything. And they refused to acknowledge me. They came back, and then we had Cook J, and they tried to get me to fight my case in the case management, where you're just only supposed to be talking about court times. And I refused to. So he struck me out, you see, because they said you're unintelligible. And they said you're too stupid for us.
So expecting us to walk away with their tails between their legs after that.
So
and vexatious, didn't they also call you vexatious?
Yeah, they called me vexatious.
That's in their cabinet manual they were using. They were trying to dispel you out of the off with you.
Unintelligible, vexatious. But I don't mind, because I have since looked at the Chesterfield's case that they sent to me, and it gives the criteria for strikeout. And unintelligible is part of it, but it's only one very small part of it. It's supposed to be, strikeout is supposed to be done on a very, very, very rare occasion when they just can't do anything with the case. And but all of the points that they said that I didn't have, well, they didn't. They only said this. They only said unintelligible, and they didn't say why. but they're supposed to say unintelligible and they're supposed to give their reasons why. And they did not do that. So yes, and then they called me vexatious, but I didn't come under vexatious because vexatious meant that you were trying to hurt them and looking for money. And I have not been looking for money, obviously, because but yes, so just Palmer J ordered them to come in and fight the case, but Cook J ordered the strike. It's a little bit complicated. They had added another case on that they shouldn't have. We had put another case in and they added it on and it all got mixed up. But never mind, that's gone now. We don't need to talk about that. So anyway, we'll come back and do some videos again later. But this is all very exciting. So we're still waiting for the hearing. Unfortunately, we didn't get it today. Sorry, everyone. But
Right. It doesn't matter, the ball's still in their court, and so it's up to them to respond.
Yeah.
And we'll see, because I might have to be calling them unintelligible, because I have actually said that they are unintelligible, because I said that by them not explaining unintelligible, that made them the unintelligible one, because I couldn't understand why they thought I was unintelligible. Because you have to say why. You get that on Facebook all the time. Someone will come and say, I'm not allowed to swear, am I? Am I allowed to swear? I always swear. Because someone will come, no, I'm not allowed to swear. All right. Someone will come and
Not
say,
with that hat on.
all right, I've got Queen's hat on. Someone will come and say to you, oh, Kate Floss, you're a ratting bitch. Can I say a ratting bitch? They'll come and say you're a ratting bitch. That, what you said there is stupid and you're a ratting bitch. Not rat like a nut. And I would say, well, you can't just say I'm a ratting bitch. You have to say why I'm a ratting bitch. Why do you think that what I said caused you to think that I'm a ratting bitch? And then if you do that, then I can rebut, can't I? Or I can see why they thought that I was a bitch, right? So that's the same when they say because I had a case comparison with Sue Gray. Because Sue Gray went to the court and the judge also was going to strike her out because he also said that she was unintelligible, not unintelligible, but so he said that she did not pass process of the court, but he gave her the reasons why, and then he gave her the way to go and fix it. But
that's right. They've got to give you a remedy. They've got to give you a remedy.
And they didn't tell me why they didn't understand my case, and they didn't tell me what they wanted me to do to remedy it. They just said, go and write the whole thing. And the risk of writing the whole thing is that one doesn't pass the court process, which is what they planned. That's what they planned. And I knew that straight away. And I think I've said it before. I'll just say this one more time. A very important issue for you common law people is on the fee waiver thing. It's got on there that if you don't get the fee waiver, that you won't, if you don't get the fee waiver, then you won't be able to continue with the case. And a lot of people will tick that. But it's just very lucky for me that I had seen another case where he had gone to the appeal court and he had ticked that my case couldn't go forward if I didn't get the fee waiver. So the judge said to him, even though I think you're correct and that you should not have been struck out in the first court, he said, since you ticked that you wouldn't have the money, he said there's the risk that when you go back to the first court, if you lose, you would have to appeal to the second court and to the Supreme Court. And he said, obviously, you don't have the funds for that. So therefore, in the interest of taking care of you and pastoral care, I have to reject your appeal because I know you wouldn't be able to cover those costs and I wouldn't want you to be wasting your time. So don't tick that one, whatever you do. Don't tick it. Just say, so I didn't say I couldn't pay. I just said I didn't want to pay. That's it. And I gave them the reasons why I didn't want to pay. And yes, so just say that, because then at least you might get through a little, and then by that we were able to appeal the $1,000, right? And that just gives us the opportunity to get a dig in, doesn't it?
Like you said though, that case, and that case where they even helped the guy rewrite his stuff.
Yeah.
I can't remember.
Yeah,
They
that's
even
in
helped.
Chesterfield, yeah.
Yeah, they helped him. But you've done, which you know, we laugh about when we first went to court, and then Kate presents and she's sitting there all smiley with the flag behind her and that. And we joke, Kate says, they must have expected, we don't know what they expected to see, but when she came up, the judges must have been thinking, what the hell have we got here? But since then, you've done your due diligence, because we've read those cases. We found it's all fallen into our laps by accident. Those cases we came upon that sort of guided us of what to do, what not to do. But you did the due diligence and understanding the language, doing the reading, and comprehending what we're reading is this stuff just doesn't happen because
it's divine intervention. I've been following these guys for a while, man, and the way you come up with all the right bits at the right time it's beyond anything any individual's doing, that's for sure.
Well, I don't know, because it just does seem like someone's following me. It does, because the cases just seem to come up when it just kind of pops up. Or even some of the common law people will throw something up and I'll get onto it, and it's just been exactly but it has been divine intervention. I truly believe that. And some of them have been like very long, and we just have gone to the right section that we haven't read it all, just opened it up, and just something has scrolled down and seen one word that has said to me, I need to read that. And I stopped and read it, and it's exactly, and I've thrown the whole document out except for that one piece that I needed. And so that's happened time and time and time again. But I just think that God, I really believe, I know people don't like to talk about God, but I just really believe that God's been looking down at all you guys that have been working so hard to get your truth across, because everything what you've been saying has been true, but they've just been sneakier than you. They've just been sneaky. See, you've been walking truthfully and honestly, and they've been sneaky. I believe they've been sneaky and deceptive and not acting honorably. They have not been walking in honor as they should be. And I think that God has just finally looked down and he said, right, but because I've said so to some people here, is because I've been teaching over here for 30 years. And it was only that I understood with children that can't read, that you had to take them right back to the beginning and then go through all the steps. And so that's what I had to do, is go right back to the beginning, go to all the steps and look at every law and look at every person, what's he saying, what's he, she all saying, and then try to bring it together. But I think this has been the hard place for the common law people, is that all of you are the brightest people, and you knew what you knew was correct, and it is damn well correct. But even though you say that they don't walk in honour, but it's like, I think in your heart of hearts, you're still expecting that they are walking in honour when they're not. I think you don't really quite know how deceptive they've been towards you to stop you. And I'm just trying to expose that. So it's just that it's vindicating what you've all done. We
did get a Mr. Moody, and I hope he sees this. I don't know if
Yes,
if
we
it was
got
an
him, Mr.
accident
Moody.
or he came in and then suddenly he's gone.
Gone. Gone.
We had two
Gone.
cases in the
Little
court.
bit of time that he was there, he worked his miracle, and then he was gone. Divine intervention, definitely.
We had a man, we put two cases in, Norm. My first case went in December, and I used certain laws, and they didn't pass, they threw it out, and I didn't get it in. And then the next case, the Yardley case, they used exactly the law that I had used in my case that they threw out, S28 of the 1990. I put it back. I went and looked at that, and I learned a whole lot from that, and I put in a whole brand new one, still on the same document kind of thing. And then that one got thrown out, and they preempted me again. And then this third, and it came up in another one of those Sue Gray cases. And then this third one, for someone, this guy turned up, Moody, he just turned up and it sailed through. And then as soon as it sailed through, he left.
Wow.
He came for the shortest time, like maybe about 2 weeks, I think, 3 weeks. He sailed it through and he left. And then another guy came in, and that was the guy. And then everything went pear-shaped from that guy. Because I think it just, in our imaginations, Moody saw that we were safe. We were there with the judge. Everything was ready to go, only case management. And then this new guy come in, and he, and everything went pear-shaped, everything. But as it turns out, it's worked out well, because now we've got 4 chances. Before we only had 1 chance, but now we've got 4, 5. We've got 5 chances now. Got
With the
this
possibility of the last one having 5 judges.
Oh, we get 5 judges. No, we got the 1,001, then we got the 7,000, then we got the 2,001. So we got those. That's 3 cases that we can use. And then we've got the actual appeal, which we will have 5 judges to decide if we get to go back to the first court. And if we lose that and they say you can't, we can appeal that to the Supreme Court. We're in the heavenly realm. We ain't gonna leave there. I'm not leaving there. I've got my hooks in, and I'm not going to leave there until I get my declaration. You know I'm not leaving, don't you, Norm?
Oh, it's beautiful.
So we can go for the Supreme on all of those. And then if we can...
Stay on the 1688. Stay on there. We're on the right path.
Yeah, that's what Hokie says, isn't it? He said to me, what got you in there? It's 1688, and so that's what will keep you there. So we don't use anything else. Don't use anything. Just stay out of there. Don't go into their madness. Don't let them lead you, because they're mad. They're mad. They're bark raving mad. Yes, you heard it from me. Bark raving mad. Aren't they? Bark raving mad is what they are. And so it's no good trying to go into there.
And are you going to mention the possibility of your German, whatchamacallit? What's it called? The
German settlers.
Yeah, the German settlers, the possibility, because that was made between...
Yeah, I think we'll do another video with that, and we'll put up all the other ones, Maxine, with Norm. We'll bring Norm in for that.
Yeah, but that could also take you out of New Zealand across the waters.
Oh, yeah. Well, that one, because that's directly, see, they're telling you can't go to Westminster, but I believe that we can. I believe that we can go direct to Westminster, but we'll go the Supreme, and then we can go direct to Westminster, because it says it. It says it right there. Here, there are many of these, Norm. I don't know if you've seen them or not, but there are actually many of these.
What?
See this?
You're
Turn your
right to
sound off,
petition the
Brent.
captain.
Brent, turn your sound up. Brent.
Oh,
Brent,
no, I did give them some.
Brent,
Oh, sorry.
turn your sound up. Ow. You see, there are many of these documents with names of the first ships. We've all got them.
Yeah.
There's some for the Scottish, there's some for the Irish, there's some for the English. This was the German one. The St. Pauli people, the people that came on the St. Pauli. Now that is connected to this bills of exchange here. Whenever they make a law that's repugnant, we can reject them here. I do protest the said bill of exchange. You see here, no?
Yeah.
So this is how we protest their monies that they've ordered us to pay with the 1688. So this one here, there are many of these. This is only one, but we've got many of them. And it just says here that this is for this is a ordinance, which is a royal decree, and it says that recently settled it, Her Majesty. Now this is nothing to do with the New Zealand government or the Maori chiefs. This is a direct covenant with Her Majesty, Queen Victoria, has been graciously pleased to assent to the removal from them of the disabilities to which aliens are by law subject. So they took away our alien subject, our alien status, and they removed our German nationality, and they removed our alien status. And then it says, all in singular the persons particularly described in this schedule whatsoever are deemed and taken to be and to have been. See, deemed and taken to be and to have been. From the 14th day of June 1843, natural born subjects of Her Majesty. So we were adopted directly by Her Majesty, you see? And so these courts in New Zealand have got no power over us if they make any laws repugnant to our 1688. And as if they had respectively been born within the realm of New Zealand. What you see here is they didn't make us citizens, they made us direct subjects of Her Majesty. So our covenant is with Her Majesty and not with the courts or with the New Zealand Maori. And so
that's right. By making us subjects, they brought us under the protectorate.
yes.
That's why we the Union Jack on our flag in the canton. It's the protectorate.
Well,
It was their safeguard.
well, this was under the King's, this was done under the St. George Cross. Wasn't done under, and then this, actually Tamati Wakanene, he's got one of these also, and a couple of the other chiefs have got them, and they had to, for us to have our alien status removed, the kings in New Zealand had to have agreed to it. They must have. There is no way that the Queen could take the power to remove alien status of foreigners coming into New Zealand without those kings' approval. And it shows...
That's right, because they could see, obviously Wakanene, he was a very foresightful man. What an intelligent man he was, man. He could see what was coming, he could see what was happening, and he did what he did as to protect the native titles. It's beautiful.
That man, when he did that, that went out to all the Aboriginals in Australia and all of the people on the islands, all native people in every single Commonwealth country went basically under him.
All the realms.
All the realms. and they all came under the protections of that 1688 because of him. So he was the other legs. We were the leg in England through the wars that happened over there between England, Scotland, and Ireland. But he was the one that did it for all the natives. If you go and research him, they've done him a great disservice. They have put up a big statue of Te Rapura, who was the one chopping off all their heads. And he actually was the one that stopped all of that. He used to have his picture on, they used to have these tea trays for having a cup of tea with it. You remember where they had the Queen's picture and all of those things? Well, his picture was on those and sold all across New Zealand. That's how revered he was. And they have somehow just flipped it and made the other chiefs above him. And I think that this is what's been done wrong. But anyway, that's another story. But he is the greatest, probably one of the greatest men that has ever walked the earth.
And his tattoo,
and
we found a very similar.
Yeah, and his
very similar pattern to his tattoo. You
yeah.
can tell him where.
Well, I can't remember, Maxine.
On the Bible, the old Bible.
Oh, okay. It's a bit far out for all of you lot, but we've seen. So I'm a Sextus, and there's an ancient Bible from the early pre-1500, from one of the first Bibles, which has got the Sextus name in it. And Sextus, the Pope, battled with Ardern way back in the 1500s. So my family and the Ardern family have touched base through many hundreds of years. And the Bible that we found has got a T at the front of it with the circle, the exact circle that is on Tamati Wakanene's face is on that Bible. So, so
According.
What they've been messing around with is deeply, deeply biblical, and they've been doing very bad things in God's eyes, I can tell you. And so that's why we're getting so much divine intervention. But yes, if we went to the Supreme Court and if they turn us down, because of that document's got my ancestor's name on it and I'm a descendant, anyone that's on these documents has a direct covenant with Westminster, and they all know that that's where I'm going. I'm going and I've got the money, and don't think I haven't. I'm not a rich person, but I've got just enough money to get on a plane over to England and Westminster. And don't think that I won't, because I will, if God willing that I'm not be gone. But I hope I'll be here. But even if I'm not, one of you guys like you, someone clever like you, Norm, you'll be able to pick right on up on it and send it off to Westminster.
You got this, girl. You got this one covered, girl.
Yeah. So we can go to Westminster. So everybody just hold on, but we could just got to wait. But everybody stay with us. But we're working for you, and I think we're going to be able to get some relief. I just want to create some relief, because I know that there's one person went to the prison. One person went to the prison because he went, and I assume he knocked down one of the 5G towers. Is that what he did? And he's in the terrorism prison. Yeah. And then we had another guy that was in a private Telegram meeting, and he threatened the person up there, and somebody recorded it and sent it to the police, and he's facing serious charges. Oh, these are lovely people that have got families, never committed a crime in their entire lives, and just lovely people that are so frustrated. And this is why they have to open up the courts, because you people have been fighting for all these years, and people have tried to use the law like they wanted them to, and they have lied and deceived them to stop them. And so people are doing things now because they can't cope anymore. You know, they're threatening and they're destroying things and they're using weapons because the government is causing that to you, because they have stopped you from going to the court. If they had have let you people in the court, because you people don't care if you lose, do you, Norm? You just only want to go to the court with your questions and you want the court to answer you. Is that right?
That's right. We're seeking clarification. That's all we want.
That's all you want.
The waters are real muddy at the moment. We just want to be able to clear these things up and see where we're going.
Yes, you only want to know where your legs are standing. And they've been hiding it for decades, and I think it's very unfair since pre-1986, since 1975, they started all this, and they've just, I don't think they've got any right to treat people like that. It's cruel.
Well, that's why you've come along, mate.
Yeah, it's like that political activist that's in jail. He's been in jail since December the 8th. And, you know, he is a journalist. He's, you know, independent
Does
journalist.
anybody know his name? Because I'd love to put a plug in for him. Does anybody know his name?
Oh, God, we had his name. We put it up there.
Yeah, grab his
Jody,
name.
Get his name. But, you know, I mean, he's been in prison since December the 8th, and he's in with criminals and things like that, murderers. And yet I think there's someone recently that's beaten up their wife who was pregnant. He may have even killed her, but he's got an ankle bracelet. Now, why is this guy locked up and he cannot get bail? He's applied 3 times for bail and he can't get bail. It's so corrupt.
That's that one his wife's name is Martha, eh?
Yes.
Yeah.
We'll get this guy's name.
Yeah, we must get his name. This man is a family man. He's got a couple of kids, and I think they're gonna have a go at using the Terrorism Act on him.
Yeah, and his wife, Graham Phillip, his name is.
Graham Phillip.
He's been charged with sabotage, and it's believed to be the first time in New Zealand history that sabotage, you know, has been used. I think they tried, first of all, it was on willful damage, and now they're going under this sabotage act that hasn't been used since they implemented it from the war. So this is how bad it is. They've really tried to, and every meeting that's been set up with his wife to just have a meeting just to touch has always been sabotaged as well. It just never happens. He's had no communication since December the 8th. He has not seen his wife and spoken to her. Maybe a 5-minute phone call, but yeah, there's a lot of corruption going on in the prison, in the corrections.
And I think he's do you know much about him? Like, was he a farmer or he had?
He was an independent journalist. So he had his own radio show or something. So he's always been, you know, for health and, you know, just against that, you know, like responsibility, I guess. I mean, he's always called it out. So I'm just having a lot. I'll see what he's.
You know, he's a lovely, lovely, lovely man, but the charges he's facing are horrendous. And very heavy sentences, very heavy sentences. Now, I just want to say about the guy, there is a bit of a worry. I'll say this very, very carefully. The man that's representing him is a man called Mr. Haig, who represented in the Yardley case. He was the man that went in on the Yardley case, and he's the one that used the human rights. And it's just such a worry that the lawyers that they're giving them are human rights lawyers. And with my very limited knowledge, human rights lawyers are not the same as criminal lawyers. Are you right there, Norm?
Yeah, I'm just going to shoot out for 5 minutes. I'm still
Okay.
here all-
So human rights lawyers, to my knowledge, and I'm just Kate Floss, but to my knowledge, they're not criminal lawyers. And if you're a criminal, this often happens, because we had a case over here of 2 people that went up for murder, and a human rights lawyer stepped in to defend them. And human rights lawyers have got very, very different training to criminal lawyers. And for him, he would need somebody who's trained in international criminal law because of the laws that they're using, not a human rights lawyer. And once they bring that human rights, I'm just going to say to this man's wife, if she can hear me, but sometimes once they bring in human rights lawyers, they fight using human rights and not using the criminal law and all of those kinds of things. And I think that I think it's I can't say it's bad for your case, but I just think if you're in there on a criminal charge, then you should have a criminal lawyer. And if you're in there on a human rights for your job that you've been discriminated against, then you have a human rights lawyer. But neither the two should mix. Jody, do you want to say something? Can't hear you.
I've just found his name. His name is Graham Phillip.
Yeah, I just said that, Jody.
Oh, did you? Sorry, I was out of the room looking for my phone.
Oh,
I already told you.
Sorry.
Graham Phillip. Yeah, Graham Phillip. Thanks for that, Jody.
Yeah.
Thanks for that, Diane. Yeah, Graham Phillip. So that man in Yardley was Mr. Haig that wanted to put the International Covenant onto S28 of the 1990 Bill of Rights. That was Mr. Haig. And so, you know.
So the human rights laws are aligned with United Nations, isn't it?
And nothing
it's
to
all
do with
about,
criminal
it's
law.
about infiltrating our judicial system
Yes.
with those human rights.
We don't want human rights people.
Yeah.
And the Terrorism Act, if they prosecute him, if the sabotage comes under the Terrorism Act,
Yeah.
then they'll be using United Nations
Thank you.
law,
Yeah.
and that plays right into their hands with Mr. Haig.
It does.
Yes,
It's perfect for what they are trying to do.
yeah. And
They will use.
and I would be nervous about that without wanting to say, because of it. Just announce to everybody that this video is for entertainment purposes only, and none of us here, I've got a high school education. I'm only just saying, we're just discussing our concerns about the case. We're not giving anybody any advice or any legal advice, but we're discussing what we feel concerned about from the limited knowledge that we have. So that's just the shout out and disclaimer. So, but yes, he is a human rights, and the Terrorism Act is full of United Nations, but is better if he can get his way into criminal law, where he's got a better chance. I mean, than using human rights. But I mean, that's a very sad case, that, isn't it? Graham, is it Graham Phelps, Jody again?
Graham Phillips.
Graham Phillips. And then there's the other guy, isn't there?
Yeah.
That there have been some people, you know, there have been many people that have been in Zoom meetings that have had their common law courts, and they've given sentences like, oh, that person's going to be burned alive, or that person's going to be hanged, or that person. So, but they don't see it as having any meaning, because they are just, it's like a pretend court. They're having like pretend courts, right? And they're basing their sentences based on a mock court of the ancient times. So they're using ancient laws that aren't even in existence. But one man was in a private telegram show, and he had said, and I won't say who he said it was, but he had said that that person, the sentencing was to go to be hanged. And somebody inside that secret meeting had videotaped it and sent it to the police. And he had gone, but unfortunately for him, one of these common law people was sitting with him and telling him the way to fight his case is to go into the court and say, I don't recognise the judge, I don't recognise the court, and I don't recognise the name. Well, you can look at my case here. That is exactly what they did to me. I gave them service papers from the court, and the Crown said to me, we don't recognise your service papers. Well, that's against the court, because they basically said to the court, we don't recognise your paper. The appeals court sent them a letter and said, you will come, and if you don't come, we will carry on the case without you, and whatever happens in the case, that's going to be the outcome, and you'll have no say. Well, this is the same when you've got a criminal charge against you, and that man has, and if he goes in the court and says, I don't recognise the court, I don't recognise your, then he loses his opportunity to speak in his own defence. So they will carry on the case without him. And and so that's what they were advising him. So I was very concerned for him as well, for this thing. What do you think about that, Norm?
Well, that's right. You know, you can't be arguing a jurisdiction where it's got no weight whatsoever and is not recognised in a court that can't deal with that jurisdiction. So you're screaming to a brick wall, really. I mean, you're wasting your time.
You're yelling at a brick wall, and it doesn't, even though, because all those common law things, as you've said, they haven't let you in the court yet to challenge those things. So therefore,
well, no, that's not quite right. We have got into the courts, but the argument that we're using in there is that very thing. We're saying, oh, we're not the name entity corporation that you're administering at the time. But in actual fact, once we take charge of that, then we can become the administrators and the true beneficiaries of that trust. But the thing is, we've just been going about it the wrong way. You know, we've been trying to argue a jurisdiction and saying that, oh, your jurisdiction, Admiralty jurisdiction, doesn't apply to us. We're in this jurisdiction, but yet we're standing in a court that only recognises the Admiralty law jurisdiction. So, of course, that argument's not even fly. It doesn't even fly.
No, it doesn't, no. Because, well, it's like a cat and a fish, isn't it?
That's right.
The cat can't go into the water and the fish can't come out the water.
That's right.
So it's a cat and a fish, isn't it?
There's something fishy going on, all right?
Well, there's a fishy, well, it's fishy, but I mean, you know, but it is just the truth, because
that's right.
The cat can't go in the water and the fish can't come out the water. So you're just stuck in this place where nobody can go anywhere. And so that's why it just falls flat, even for them, even for you. So
that's right.
You have to find a way to recognise certain. Everyone told me not to go into the court because they said because you recognise them, but I'm thinking, you know, you've been doing that. So I just want to find a different way, but I'm just, these poor people that are going up on criminal charges, they're going up on criminal charges. It's so dangerous for them to use the common law because they do just lose all of their opportunity to speak if they do it. I'm just saying, well, please don't do it.
Especially see, common law is the result. Written common law is the result of private disputes being settled in public. So And those public decisions become precedent, and that's what sets the written common law. And so you're dead right, going in there, trying to argue another outside jurisdiction when there's already precedents been set within the jurisdiction that they're operating in. I mean, it's oil and water.
Oil and water. Better than a cat and a fish, isn't it? Yeah. It is. It's oil and water.
See, here's the thing, all that political realm, all that jurisdiction, all that juridical precedences and things, they all stem from and get their power from the 1688 Bill of Rights. And that's it. And that the 1688 gets its power from us. And the godly realm. We did that because we said, our ancestors said to them, if you want to govern and you want to have courts and you want to have the kings, you've got to do this is our bill to you. And you follow this. And if you don't follow these obligations, because if you read that New Zealand Challenge to Change, they were discussing it, and Joseph Savage turned around and said, if we don't follow the law, they no longer have to recognise our law. He said it. They lose their power. They lose all power. The minute that we bring in that 1688 and they have written a law that's repugnant, and if they don't uphold it when we've challenged them in the court, their whole system falls down around their ears, and that is when you have the right to completely take the helm, because they didn't fulfill the promise. That's right. They've closed down your avenue for redress. Yes. They can't do that. They're not allowed to. Yeah.
I think they don't like the 1688 because it's understandable, even to the layman. You have to be pretty stupid not to be able to fucking work it out. It's understandable. It puts everyone on an equal footing. As far as understanding, and then being able to go and what do you call it?
And it has clarity.
Yeah, and it's got clarity, but being able to say, because the laws today, you need a solicitor, because, or even the bills that they're putting out, you're jumping from one to the other, and now with the international law coming in, that you'll never get it. I've tried to read that shit and listen to videos, and the 1688 keeps it real. It's very clear, and it gives you remedy. The remedy.
It gives remedy. It does give remedy, and it is there, but it is by getting that. You don't need a solicitor for that. No, you don't. But if you get the declaration, it orders them all to stand down, and then if you want to go and get remedy because you've lost in some way, you need a solicitor then. So that's different, because then you're going for litigation for money. But if you're going about a point of law, the 1908 Declaratory Judgment Act says that one person who has it doesn't even say that it needs to be anything wrong with the law. It says you only have to be interested in a point of law. That's it.
Okay, so Kate,
yes,
when it comes to the point of taking a solicitor to the court, to the Supreme or High Court, what solicitor is going to take this on? Because they don't understand it at this point in time.
No, they do understand it, but there's no money in it for them. They don't get the money in the declaration. There's not any money, so they don't.
Well, not in the declaration, but the next step.
What do you mean?
Well, you know how you said we need solicitors to go to the next, to take our case
We'll get
forward,
paid.
if there's a case.
I'll get paid because it's litigation, isn't it?
Yeah,
Yeah,
so
that's right, mate. They'll take
come
some-
to teach us then.
You can get that declaration from the Supreme Court, mate. There will be lawyers knocking at your door the next day because they can see what's coming.
They have to
There's something-
sharpen up their 1688
Knowledge,
understanding,
knowledge, yeah,
That's
knowledge.
that's right. They do. They have to sharpen it up. I
Which
mean,
means it gives us a job.
yeah.
But
Yes, it does. We can teach them the
They
1688.
come here. They come knock on our door, listen.
They'll be
I don't
knocking
need
on
any
our
more
doors.
work.
Yeah.
I don't, because I wanted, everybody knows that I wanted to do comedy, and I never wanted to do this, but I just
It was comedy.
I wanted to do it. So it's my hope and my dream that I would be able to open up the courts for you common law people, so that you can get in the courts and do what it is that you've worked so hard. And at that point, when you're able to do that, I intend to just step back. So it's not my intention. I only want the reward for me is that if I get the declaration, I know that my name will be in books for all times to come. I know that 50 years from now, my name's going to be there with Jacinda Ardern. And so that's the reward for me already. If I get it, it's going to be huge. But at that point in time, it's time for me to step back and go back to my comedy, because I'll be able to swear and everything again. And yeah, and just sing, and I just want to do those things. So I just want to get this out the way for you people. And but then I'll be famous, which is what I wanted, was fame. So then I'll get some fame, and it wouldn't be my intention to go to, get a solicitor to litigate or anything. It's not. It really is not my intention, and I wouldn't
But
do
you-
it.
No, not
also-
for you, but for others that after you've got the declaration and want to take cases to court, and you were saying that they need a solicitor then if they're going to get some compensation of some sort.
Yeah,
Jody, there's not many Kiwis in New Zealand at the moment that wouldn't want to take Jacinda Ardern to court if they can get the opportunity, mate.
No, I know that. Yeah.
I say, man, the solicitors will be knocking at your door.
But you also, Kate, you, the passion has been driven to save our country.
Absolutely.
yeah.
For you,
Absolutely.
that has been huge for you. Like the fame, yeah, I had to tone that. Yeah, we had to tone you down on that one. But your driver has been to save New Zealand, for New Zealand, for us free.
Our
Yeah,
country,
the
New
ones that-
Zealand, because
Yeah.
you can see the beauty of what our country was built on. The pain, it was an accumulation going all the way back to the time of Romans when they invaded Germany and destroyed the Germanic tribes, all the way over to England when they destroyed the Anglo-Saxon tribes and the Irish clans and the Scottish clans, and then it went out into the world, into New Zealand and Australia, and how all the pain and sorrow and hell that dozens of generations have been through, to end up with a beautiful Commonwealth and a beautiful country of New Zealand that we all lived peacefully, worked together. And I think it was very nice what Tamati Wakanene did and what Queen Victoria did, and all that our peoples had been through to come out and finally have a reasonable civilization, mainly through what happened in New Zealand. When you think of the poor native chiefs who had their heads decapitated and hung on a wall in a museum in America, and then if you think about all the Anglo settlers that were tricked into coming to New Zealand, and many of them starved, were whipped and beaten, and many of the children were decapitated and burned alive, and this is a fact. There are children's graves all over New Zealand that were burned alive, and
Yes, it's a fact.
this happened to both of our peoples, and then to come out of all of that with the beauty that they all got together, they all sat down and they said, we don't want our future generations to have to live through what we've had to live with. And what they come out with was a beautiful thing. And for someone to come along and destroy what we had built together in that country of New Zealand, we worked hard, man. We built those roads, we built those hospitals, all of us together. Not a single one of us was not involved in it. From the learning how to, learning how to eat the food of New Zealand, to boil ups, making the boil ups because we were hungry, and the Maoris had to teach us how to cook the Maori food so we didn't starve. First thing we learned to cook was doughboys, and who doesn't remember oxtail soup? And who doesn't remember you get a big pot and you just throw the water in and throw in a cabbage and throw in some meat and some potatoes, and that was dinner. That lasted you for a week. And we
had boil up the other night and fried bread and doughboys.
Yeah, all we've worked for, everything we've worked for, we've done it together. And to have anyone come along and just think that they can destroy that, no, I will not allow them. I will not. No.
That's right.
To do that to us. No. So I love New Zealand. We all love New Zealand greatly. And to come along and just change the name of our country and change. Yes, dear. Brent.
I'm going now.
Yeah, we're going to go now. It's just raving on time now, isn't it? But I do love New Zealand. Right, we'll say goodbye, everyone. See you later.
See you next time.
Yeah. Bye-bye. Bye. Let's see. Bye, Maxine. Bye, Norm. Great to have you. Bye, Kate Floss. Bye, Sharon. Bye, Brent. Bye, Jodie. And bye, Diane. Right, we'll be back. See you later.
Thank you.
All right. Stop recording. Smile.
The recording has stopped.
All right. Now I've got to do my YouTube to stop. All right.